Hello, I am Mahen Pratap Singh. Welcome to my channel News Simplified. Here in this video, I am going to talk to you about Article 21 and 22 of the Indian Constitution. As you all know, the Constitution of India is a very vast constitution. It encompasses almost all the aspects of polity, good governance, welfare of its people, its citizens. Almost every aspect of life is touched in our constitution, one of the most beautiful constitutions of the world. It guarantees fundamental rights to its citizens in its third part, whereas in the fourth part, it guarantees welfare for its people through its directive principles. There is a beautiful play of the balance of power between different wings of the governance. So this beautiful constitution sometimes is mired in controversy as well. Controversies arise from time to time. When you see Article 21 and 22, you study both the two articles, the contradictions will force you to come to the conclusion that there is a kind of arbitrariness, a kind of a freedom has been handed over to the state, to the executive, to arbitrarily perform certain acts. The Article 21 of the Constitution, which comes under the part third of it, it means the fundamental rights section of the Constitution. In this part, we have a right to life, right to personal liberties. The Constitution guarantees personal liberty and a right to live for its citizens through Article 21. It also guarantees a dignified life, a respectful life, a respectable life. Now come to the Article 22. Article 22 of the Constitution talks about two types of detentions. The first one is preventive detention. The second is punitive detention. What is the difference between preventive detention and punitive detention? Punitive detention means if you have committed a certain crime, the sections of the law will apply to you and you will brought to justice. You will be detained after having committed crime. This detention is a post-crime detention. It means after the crime has been committed, and that is in no way out of any region. It means there is a reasonability behind it. It cannot be questioned. It is an ordinary uh, thinking that a person after crime will be held and he will be detained and trial will be held until he is proven innocent or guilty. Then the judges will decide the gravity of the crime and he will be accordingly sentenced. Now come to preventive detention, which is the point I want to talk to you in this video. Preventive detention is before crime. It is a confinement without court trial. It is based on suspicion. It means if you are suspected to have to a future troublemaker, disturbing element in the public order, you can be detained and put behind bars, and that is non-bailable. You will not be able to get bail out of it. It protects against arbitrary or ambiguous arrest. Here, this can be misused. If a person is deemed to be a threat to public order, he can be captured and put behind bars. This is so easy for the state to do. Sometimes political scores can be settled. Sometimes people who oppose the policies of the government can be meted out the same arbitrary justice. Let us just try to know what the current activity in this regard is noticeable in India. In a judgment, Danya M versus State of Kerala 2025, the Supreme Court of India underscored that the extraordinary powers of preventive detention must be exercised sparingly and strictly in accordance with the constitutional safeguards. It means safeguards must be followed, and the apprehension about arbitrariness and a kind of a suspicion, and behind that a political score to be settled must be taken notice of before making any arrest. Reaffirming the principle that individual liberty cannot be curtailed lightly. It means the state cannot deny the citizens their right to freedom, their liberty, as guaranteed in the fundamental rights. Court highlighted the vital distinction between public order and law and order. Sometimes the lower court judges or even the executive, it means the officials handling law and order of the state, cannot differentiate between public order and law and order. If it is an issue of law and order and a person is detained on that ground, that is a flimsy ground, not a solid ground. Only a detention under preventive detention can be exercised when the person really poses a threat to public order. Sometimes this law is misused in such a way that preventive detention becomes a substitute for criminal prosecution. It means if you are not being able to be put behind bars and criminal charges cannot be framed against you, there may be a kind of a suspicion. The ghost of a suspicion can be aroused to come up and just have the person being detained at the instant moment. What happens sometimes, it is also to circumvent bail pleas. The person who is going to be detained, whether it is proper or improper, whether appropriate or inappropriate, whether his arrest and detention is grounded in reasonability or not. If the executive wants that he should not be given bail, they can misuse this section. The broad definition of the ground. Sometimes executive feels that public order is at risk because it terms some people in the state as gundas and rowdy elements. You cannot define so easily who is a rowdy element or who is a gunda. The definition can vary from people to people. Sometimes an innocent person can be termed as gunda who goes against the state policies. He becomes a critic of the state. He can be termed as gunda and can be detained under this Preventive Detention Act. Now let us have a look at one judgment, the same judgment, Dhanya M versus state of Kerala, and another Rekha versus state of Tamil Nadu. Rekha versus state of Tamil Nadu, in this court held that the power of preventive detention is an exception to Article 21 and must be treated as such, an exceptional measure to be employed only in rare circumstances. Discretion has to be exercised here. Wisdom has to be the key to know whether the detainee is not pressurized or it is not illegal on the part of the people who are going to detain a person, whether the grounds are really solid to have a person behind the bars or it's right to detain him. Exceptional measure to be employed only in rare circumstances. Likewise, in Banka, Sneha and Sheila versus State of Telangana, the court reiterated that any action involving preventive detention must be tested against the standards of Article 21. Article 21 guarantees right to live, right to personal freedom and personal liberty, and this cannot be snatched on the part of the state on flimsy grounds or on the grounds of suspicion. Yet, executive overreach continues unchecked in the domain of preventive detention. Preventive detention law is widely and blatantly misused by the executive, and it is far from stopping. This law is a colonial law. Its first mention or its first established uh, regulation is seen in Bengal Regulation of 1818. The Bengal Regulation of 1818, devised by the British to maintain colonial control, the Government of India Act 1935 empowered provincial legislatures to enact preventive detention laws in the interest of public order. It was for the maintenance of the public order that the British enacted this law, but they employed this law only in the wartime, in not normal practices, day-to-day lives. Independent India inherited and retained this colonial relic with astonishing zeal. But this is unfortunate that Indians embraced it so warmly. The Indian Constitution gave its nod. This matter was widely debated and hotly debated in the Constituent Assembly, but there was no escape from this draconian law. Occupying an ambiguous zone between the formally extraordinary and the practically ordinary, this Article 22 of preventive detention, its ambiguous zone in the Constitution, it is formally extraordinary. It means it cannot be applied in normal conditions. It must be applied sparingly, and this cannot be adopted in cases that are all and sundry. All the cases. It means discretion has to be exercised before making a decision on a person to be detained. But what in practice it is an ordinary practice. It means whoever is suspected to create a public a threat to public order can be detained and put behind bars. It is this preventive detention was thoroughly embedded into the Indian legal landscape at the time of independence, so much so that facing a situation of communal tension, communist uprising and the partition, it turned into a public order tool under the newly independent federal and provincial governments. It means at the time the British were ruling our country, it was widely taken up and it was widely misused. But the misuse has not reduced even after the independence. Even when India is a constitutionally a democracy, where the wishes of the people, the rights of the people override all considerations. In spite of all that, the misuse is going on. Article 22 is in a way a Janus-faced provision. What is a Janus-faced provision? Two contrasting qualities found in the same thing. Is Janus faced provision. On the one hand, it advises the executive to act wisely when you are going to detain a person. On the other hand, it is a common practice for those people of from the executive to apply this preventive detention whenever the need arises. You just take it up. I want to cite one of the earliest cases regarding this. It was A.K. Gopalan versus State of Madras, 1950. It was a litmus test for the nascent republic's commitment to the constitutional citizens' right to life and liberty. Gopalan was a communist leader and he was detained under colonial law under later revalidated by the Preventive Detention Act 1950. He challenged his detention under Article 21, the right to liberty and the right to live, citing the absence of procedure of established by law, and under Article 19 alleging a violation of his freedom of movement and speech. The court, however, rejected his claims, holding that preventive detention could only be tested on the basis of Articles 22 from class 3 to class 7. What does it mean? It was the earliest cases, one of the earliest cases in which this law was going to be tested. But the Supreme Court ruled against Mr. Gopalan, who was seeking justice under Article 21, that his rights under Article 21, fundamental rights, had been violated. He claimed this, he wanted to establish this, but the court said that it cannot be accepted because your freedom is guided not by Article 21 but it is guided by Article 22. It means the court did not accept the role of fundamental rights in determining whether this person was legally detained or illegally detained. It was not ready to consider on that ground. When the golden triangle eclipses, what is golden triangle? It is the triangle of the fundamental rights. Fundamental rights has eclipsed in a way when we consider this law against the fundamental provisions of the fundamental right. Actually, Article 22 overrides fundamental rights, as I have already mentioned and told you that it overrides the fundamental rights. There was a glimmer of hope in one case. It was Maneka Gandhi versus Union of India, 1978, when the judges delivered the judgment that procedure established by law must mean fair, just and reasonable due process, and that fundamental rights must be read as a unified whole. In this case, they accepted that fundamental rights cannot be compromised in any way, whether it is the provision of preventive detention or not. It means preventive detention cannot override, cannot negate, cannot deny the fundamental rights of the citizen. There was a ray of hope or a glimmer of hope in that case. But in another case, A.K. Roy versus Union of India in 1982, this Menaka Gandhi reasoning to assert that preventive detention law could not be challenged for violating Article 14, 19 or even the enriched interpretation of Article 21. The court also refused to subject such laws to the doctrine of proportionality, which had become a central tenet of constitutional review elsewhere in the rights framework. Yes. Uh, the Supreme Court also denied to consider the law, the tenet of proportionality. Sometimes a law is necessary, a provision is necessary for public order. It cannot be done away with. But along with that, it infringes on the rights of the citizens. It violates some key fundamental rights. What happens? Here, a measurement of proportion of damage done to the uh, party on whose fundamental rights have been impeached, and whether it was necessary for the maintenance of public order. There is the two aspects are measured in proportion to each other, and when it is found that public order is more uh, necessary for any consideration of individual right, then it's okay. But the Supreme Court did not consider this on the grounds of proportionality, doctrine of proportionality. Thus, a person ensnared in this Bermuda Triangle of Article 22 is effectively cut off from the Golden Triangle of Article 14, 19 and 21 and is plunged into legal darkness, as you all know. All the other fundamental laws go to the dogs, are just a waste when uh, this is applied. In a way, this is called, this Article 22 is called Devil's Island, Devil's Island, authoritarian penal colony. In India's constitutional geography, isolated from the ocean of fundamental rights, it means the fundamental rights can be so blatantly violated by invoking Article 22 of preventive detention. It can be blatantly violated, and that is why it is called Devil's Island. It's a authoritarian penal colony. It means punishment can be uh, uh, anyone can be punished by invoking this article. There is also a provision of advisory board review whenever Article 22(4) is applied, but the Supreme Court has also relaxed this provision as well, and in a way the fundamental right of liberty and life has shrunk. According to Somnath Lahiri, this provision has rendered the Indian Constitution a police constable constitution. Police constable constitution. Because of that, Somnath Lahiri has claimed that the constitution has been rendered, has become a police constable constitution because of this. So now we come to an end of this video. Actually, when we view the whole scenario of Article 22, it becomes clear that it's seductive for the executive to apply Article 22 and detain a person because it is non-bailable. It's so easy for the executive to keep the person behind the bars. He cannot be able to claim his fundamental rights under this Article 22 because I have cited so many of the court judgments in which this aspect has not been considered by the court itself. So, my appeal to all and sundry, to the state, to the governments, is that they should prioritize the freedom of the people above everything, because this is the hallmark of Indian democracy. Safeguarding the people's rights, keeping above all the fundamental rights of the citizens, is the very foundation of a democracy, and India is a champion of democracy. Thank you very much for watching my video.